गुड मॉर्निंग फ्रेंड्स। जैसा ही मैंने आपसे प्रॉमिस किया था कि मैं आपको संडे को सुबह जो सुप्रीम कोर्ट की लेटेस्ट जजमेंट है जिसने रेकग्नाइज किया है अंडर आर्टिकल 21 दैट वुमेन हैज द राइट टू रिप्रोडक्शन एंड अबॉर्शन। सुप्रीम कोर्ट ने ये कैटेगोरिकली अंडर आर्टिकल 21 स्टेट किया है कि right to reproduction and abortion is not limited to the married woman due to change in the circumstances, social circumstances, as there is change in the definition of cohabitation between the two individuals. Earlier, marriage as an institution is considered paramount for the cohabitation between a male and female. But now the circumstances has changed. आज बहुत से लोग लिव इन रिलेशनशिप में रह रहे हैं। कोर्ट्स में डेली पिटिशंस फाइल हो रही हैं फॉर द प्रोटेक्शन, नॉट ओनली फॉर द मैरिज प्रोटेक्शन बट आल्सो एज ए लिव इन पार्टनर्स, दैट टू नॉट बाय अनमैरिड पर्सन्स. In some cases, one of the person is married, other is unmarried. It may be male or female. Or in some other cases, both the persons are already married without obtaining the divorce. They come to court for the protection, seeking the enforcement of their fundamental right to live and cohabit with the person of their choice under Article 21. So, due to change in the circumstances, court has interpreted the provision of the law and the rules made thereunder for the abortion to include unmarried women also. In the judgment X versus Principal Secretary, Health and Family Welfare Department, Government of NCT and another, recently pronounced and authored by Justice Chandrachud, wherein the Rule 3B of the Medical Termination of Pregnancy Rules 2003 has been given purposive interpretation, and the court has stated that women include unmarried women. It is not limited to the change in circumstances of the married woman, but change in circumstances of the unmarried woman. The circumstances does not include the breakdown of the marriage, divorce, or untimely death of the partner. In case of a married woman, it court said it includes unmarried women. Unmarried women भी इसमें आती हैं because somehow due to unawareness about the outcome of the unprotected sexual relation, there they develop undue pregnancy. They are not mentally prepared to bear pregnancy and to give birth to a child. Sometimes the sexual relationship is forcible, although in a friends. Sometimes due to consent and proper will, but without any wish to have or to bear a child. So Supreme Court, due to changing social circumstances, social condition, has included in the Rule 3B the unmarried woman also. Then the other controversy about the judgment, I being a lawyer has witnessed as the social media that Supreme Court has recognized the marital sex. It is totally wrong. In the judgment, Supreme Court has never recognized the marital sex, marital rape. That is, the matter is already sub judice pending before the constitutional bench of the Supreme Court. In this case, Supreme Court only noted a fact that violence to the woman in a domestic relationship, in a matrimonial relationship, also includes sexual violence. That is, woman is forced to have sex or to indulge in sex by her husband against her wish. Resultingly, the unwanted pregnancy in occurred, for which the woman is also entitled to abort the child within the prescribed period mentioned in the act and rules. For this purpose, Supreme Court has said women need not to show or to avert that there is change of the matrimonial relationship. That is, neither woman has given divorce to her partner, and her partner is very much alive, but she want to abort the child. Abort the pregnancy developed due to unwanted or enforced sex. Enforced sex does not mean sexual relationship developed between the two partners without the consent. It also includes sexual relation was consentful, but the woman or even otherwise the other partner was not ready for the pregnancy. The pregnancy is unwanted. What the Supreme Court has did in this judgment recognized the right to reproduction and right to abortion of the woman irrespective of her mental, marital or social status. This has been done in line with the change of the social perception with regard to marriage and privacy. I have seen or witnessed people are saying, even I say, male gender say, it is my private matter to indulge into sex, to have drinks, to drive, whom to meet, whom to care, whom to call. Mobile phone is one of the things where we say it is my private matters. Even in social media, we put logs on our profiles. Not on profiles, some thing we have shared are also put under log. These come under right to privacy. Similarly, Supreme Court recognized the right to reproduction and right to abortion as a privacy right of the woman. It is up to the woman whether she wants to reproduce or to bear a child. Accept the right to recognition of pregnancy and abortion. Supreme Court has categorically mentioned in this judgment, in his judgment, that the pregnancy can be aborted within the period specified in the enactment up to 20 weeks with the report of the registered medical one registered medical of practitioner, and beyond 20 weeks up to 24 weeks by the decision of a board consisting of two medical practitioners under specified circumstances mentioned in the act and rules made thereunder. Supreme Court has also directed the state governments and the Union of India to sensitize the medical practitioners in this judgment, and also directed that medical practitioners need not disclose the identity of the woman to any person, even to the investigating officers. Not only this, Supreme Court also recognized that the medical practitioners, due to the fear of prosecution, being prosecuted, ask the persons to get the order from the court for the pregnancy, despite there being provision under the law and the rules made thereunder. So the judgment has not only recognized the right to freedom to bear a child, to abort a child, reproductive right of a woman and her partner, extended the definition of woman from married to include even unmarried women, directed the union and the state governments to sensitize the medical practitioners about the law, and also directed the medical practitioner not to disclose the identity of any person. The judgment is just a step forward to recognize the right under Article 21 in the changed circumstances, and again I repeat, it never recognized the marital rape. It just said in a paragraph that domestic violence also includes forceful sexual relation by the husband with her partner, with his partner. So my only motive was to sensitize the society and to clarify some facts with regard to the right to pregnancy, right to abortion in view of the changing circumstances. I hope I am able to discuss these issues, and whoever watch or listen to me might able to understand the repercussion of this judgment. There is nothing wrong in the judgment, rather it has recognized the rights and issues certain direction only. Thank you very much. Happy weekend to everyone.